I will call this meeting of the Standing Committee on Government Operations to order. Committee, there's an agenda before us. Can I get a motion to adopt the agenda? Mr. Simpson, all those in favor? Motion carried. The agenda is adopted. Declarations of conflict of interest. Hearing none, today's committee business is a public clause-by-clause review of Bill 30, an act to amend the Human Rights Act, with the Honourable Louis Sebert, Minister of Justice. We'll start by introducing committee members for the record, and we'll start with Mr. Nakamayak.
Good morning or good afternoon, Herb Nakamayak from the Nukput.
Good afternoon, Danny McNeely, Satu.
Kevin O'Reilly, Freedom Lake.
Good afternoon, RJ Simpson, MLA, Hay River North.
And I'm Kieran Testard, member for Cam Lake and chair of the Standing Committee on Government Operations. With me at the table are Jennifer Franki-Smith, Committee Clerk, April Taylor, Committee Research Advisor, and Alyssa Holland, Law Clerk of the Legislative Assembly. Today, the Standing Committee on Government Operations is holding a public clause-by-clause review of Bill 30, an act to amend the Human Rights Act. Bill 30, sponsored by the Honourable Minister of Justice, proposes to consolidate the Office of the Human Rights Commission and the Office of the Director of Human Rights into a single agency called the Human Rights Commission. It will clarify the public interest mandate of the Commission and provide for the carriage of complaints at hearings by the Commission in recognition of this public interest mandate. Will provide that restorative principles are to be applied to human rights protections and processes in the Northwest Territories. It will make changes to the operation of the Human Rights Adjudication Panel, including giving adjudicators the ability to use practices, procedures for resolving complaints that are different from those in traditional adversarial processes. It will add gender expression as a prohibited ground of discrimination to expand upon and clarify the grounds of sexual orientation and gender identity for which discrimination is already prohibited under the Act. It will remove the offense and punishment provisions of the Act in recognition of the shift to a restorative process, and finally bring the amendments into force annually over a 3-year period from 2019 to 2021. Bill 30 received second reading in the Legislative Assembly on October 31st, 2018, and was referred to the Standing Committee on Government Operations for review. To commence its review of Bill 30, the committee sent letters inviting input from an extensive list of stakeholders, including all municipal and Indigenous governments in the Northwest Territories and a number of non-governmental organizations. During the week of January 21st, 2019, the committee traveled to and held public meetings on Bill 30 in Fort Smith, Inuvik, and Fort McPherson. A final public hearing was held in Yellowknife on February 5th, 2019. Committee thanks everyone who attended these meetings or provided written submissions to the committee sharing their views on Bill 30. As a result of committee's consultation with the public, committee will be proposing 8 amendments to Bill 30. The details of the submissions received by committee and the nature of committee's deliberations will be addressed in our report to be presented in the Legislative Assembly next week. There are copies of the bill available at the back of the room. I will now invite the Honourable Minister of Justice to introduce himself and his staff for the record and to proceed with any opening remarks that you may have. Mr. Minister.
Yes, thank you, Mr. Chair. I'd like to introduce the people that are with me today. To my left is Mark Aitken, ADM Attorney General, Mike Reddy, Director of Legislation Division, Yun Trang, who is at the back, Manager of Legislative Policy. Okay, and Stephen Dunbar, my Ministerial Assistant. I do have some opening comments, if I might proceed to them. Thank you. I'm pleased to be here today to discuss Bill 30, an act to amend the Human Rights Act. Bill 30 amends the Human Rights Act to improve the delivery of human rights services and enhance the protection of human rights in the NWT. The amendments arise from recommendations by the Human Rights Commission's Comprehensive Review Team, which brought together constitutional and human rights experts to review the NWT Human Rights Act on the occasion of its 10th anniversary. Specifically, the amendments proposed fall under 4 major themes. First, valuing and incorporating a restorative approach throughout the human rights system and encouraging early resolution where possible. Second, improving efficiency in operations by consolidating the Commission and the Director functions into one single agency, the Human Rights Commission. Third, emphasizing the Commission's responsibility to protect and assure the public interest through the identification of systemic discrimination and the application of broader systemic remedies. And fourth, affirming the rights of transgender and other gender-diverse persons. The bill will also make a number of non-substantive miscellaneous amendments to improve the clarity and readability of specific provisions of the Act. Mr. Chairman, I would be pleased to answer any questions that the committee may have regarding Bill 30. Thank you, Mr. Chair.
Thank you, Mr. Minister. Does the committee have any questions for the minister? Hearing none, does committee agree to begin the clause-by-clause review? Thank you, committee. We will defer the title of the bill until the end and begin with consideration of the clauses. There are 29 clauses in the bill. Please turn to page 1. To clause 1, does committee agree? To clause 2, Mr. Simpson.
Thank you, Mr. Chair. I move that Clause 2 of Bill 30 be amended by deleting paragraph A and substituting the following. A, in the second recital by adding or expression, genetic characteristics after genetic identity, and. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion's in order. To the motion, Mr. Simpson.
Thank you, Mr. Chair. This would effectively add genetic characteristics to the list of prohibited grounds to be discriminated against. This was something suggested by the Human Rights Commission, and this is something that we discussed when we went on the road to the various communities, and it received wide-ranging support from every community we went to. This is something that's done in every other G7 nation except for Canada, and Canada recently passed its own legislation. So it's become quite common now in many parts of the world, and we're just basically playing catch-up, and for some reason the bill as presented failed to include this characteristic or this ground, so that is why committee is recommending it. Thank you, Mr. Chair.
Mr. Simpson, to the motion.
Question.
Question has been called. All those in favor? Any opposed? Motion is carried. Does the minister concur with this amendment? Mr. Minister.
No, I'm afraid we cannot concur with this motion, and I'd like to give some reasons, if I may.
You may.
Thank you. Thank you. I'd like to take this opportunity to explain our position, and with your forbearance, I'll take a little bit of time to do. So first, I would say that the government completely understands the rationale for including or adding this new ground. We agree that individuals should not face discrimination based on the likelihood they may be susceptible to a genetic disease or condition such as ALS, Huntington disease, or muscular dystrophy. However, the mechanism of adding genetic characteristics as a prohibited ground in the Human Rights Act would have significant implications and could result in unanticipated consequences for NWT residents. As members know, in 2015 and 2016, the Human Rights Commission undertook a comprehensive review of the Human Rights Act and of the structural workings of the Commission and its associated agencies. While that review did not recommend adding new prohibited grounds, the Human Rights Commission did separately recommend the enactment of additional prohibited grounds, including genetic characteristics. I think the Human Rights Commission and its agencies would acknowledge that the development of Bill 30 was a collegial, collaborative, and cooperative process. The Department of Justice accepted almost all of the recommendations proposed by the Commission. One of the few areas of pushback related to the addition of this new ground. In coming to its conclusion, the Department of Justice examined the legislation of other provinces and territories, none of which had added genetic characteristics to the list of prohibited grounds. The department also reviewed the then ongoing debate around Federal Bill S-201, the Genetic Non-Discrimination Act, a private member's bill originating in the Senate, creating offenses for requiring a person to undergo a genetic test or requiring a person to disclose the results of a genetic test in order to obtain goods or services, or to enter into an agreement, and consequently adding genetic characteristic as a new prohibited ground under the Canadian Human Rights Act. Members may recall that this bill had a fairly dramatic ride through Parliament. The insurance industry was alarmed, and the Attorney General of Canada expressed serious concerns that provisions of the bill were unconstitutional because the genetic testing provisions purportedly being enacted under the criminal law power were in fact an intrusion into provincial constitutional jurisdiction over property and civil rights. However, the new government declined to apply the whip, and Bill S-201 proceeded to assent. The government of Quebec subsequently challenged the new legislation by taking a reference to the Quebec Court of Appeal. In December 2018, the Court of Appeal unanimously ruled that the provisions of the new act establishing criminal offenses related to genetic testing were unconstitutional. An intervener in the case, the Canadian Coalition for Genetic Fairness, appealed to the Supreme Court of Canada, but a hearing has not yet been scheduled. Turning back to where we are today, no province or territory in Canada has enacted genetic characteristics as a prohibited ground. The inclusion of such a prohibition on discrimination based on genetic characteristics has been strongly opposed by the insurance industry, which is regulated under the constitutional authority of the provinces and territories. In the Northwest Territories, for example, we have the Insurance Act, which provides a little light reading of 178 pages. The insurance industry has very significant concerns as set out in the letter of March 5th, 2019, from the President of the Canadian Life and Health Insurance Association that has been provided to committee. Their issues include concerns that individuals could load up on insurance coverage if genetic tests that are protected from disclosure to insurers show that they are at risk of a genetic disease or condition, that premiums would increase as a result, and that the pool of individuals buying insurance would shrink due to the price sensitivity of consumers. Beyond issues of genetic testing, and even more problematic in its view, the association points out that genetic characteristics are a very broad concept, including characteristics such as weight, cholesterol, propensity to heart disease, factors of family history that are a fundamental consideration for insurance underwriting and the calculation of risk in the industry. The association notes in its letter that, quote, that if the Northwest Territories were to adopt such an approach, it would put the territory very much offside the prevailing market rules across Canada and could negatively affect accessibility to affordable insurance products to the residents of the Northwest Territories going forward. This carefully worded statement seems to suggest that insurance products could be withdrawn from sale in the NWT, but not elsewhere. By asking the very questions routinely required for the sale of existing health and life insurance products, the industry could put itself at risk of contravening the amended NWT Human Rights Act. This may not be a risk they are prepared to take for the sake of our limited market, and any resulting decision to withdraw insurance products could have significant implications for both NWT residents and the local insurance brokers based in Yellowknife and Hay River. I would return to my initial comments. This motion does raise a fair issue, but due to limitations resulting from our legislative process, I am concerned that the motion is not the right vehicle to take us where no other province or territory has gone. I completely understand that the motions being considered today are the only opportunity committee has to amend Bill 30. This particular issue, however, is very significant with the possibility of serious consequences for residents, and it calls for a more comprehensive consultation and review than we are able to give it at this stage of our process. I've no doubt that both sides of this debate would have welcomed the opportunity to make representations on this issue, and I suspect that if this provision had been in Bill 30 as introduced, committee would have seen witnesses appearing on behalf of the insurance industry, both locally and nationally, and on behalf of advocacy groups who hold contrary views. The addition of this new prohibited ground demands a thorough review and very careful consideration, and I have no doubt we will see it in the future, but at this point we have not undertaken the necessary due diligence. Thank you, Mr. Chair.
Thank you, Mr. Minister, and I'll just remind committee members that this is not the opportunity to debate this principle, only to speak to the amendment. So the motion to amend is defeated, so we'll return to Clause 2. Does the committee agree? Thank you. Clause 3? Clause 4? Clause 5? Clause 6? Clause 7? Clause 8? Clause 9. Mr. Simpson?
Thank you, Mr. Chair. I move that Clause 9 of Bill 30 be amended in proposed paragraph 23(1)(c) by striking out "or by the Commission" and substituting "and by the Commission." Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion's in order. To the motion. Mr. Simpson?
Thank you. I think this is a technical. I have nothing to say on this one. Thank you, Mr. Chair.
Thank you, Mr. Simpson. Thank you, Mr. Simpson. The question has been called. All those in favor? Any opposed? Motion carried. Does the minister concur?
Yes.
Thank you, Mr. Minister. Thank you, committee. To the clause as amended, does committee agree? Clause 9 as amended? Agreed. Thank you, committee. To clause 10? Agreed. To clause 11? Mr. Simpson.
Thank you, Mr. Chair. I move that subclause 11(1) of Bill 30 be amended by deleting proposed paragraph 27(1)(e) and substituting the following: E, have carriage of complaints on behalf of the Commission in accordance with subsections 53(4) to 6. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion's in order. To the motion. Question has been called. All those in favor? Any opposed? Motion carried. Does the minister concur with this amendment?
Yes, we do.
Thank you, Mr. Minister. To clause 11 as amended, does committee agree? Thank you, committee. To clause 12, Mr. Simpson.
Thank you. I move that subclause 12(2) of Bill 30 be amended by deleting proposed subclause 29(2.4) and substituting the following: 2.4, the Commission shall establish a process for conducting an appeal under subsection 2.3. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion is in order. To the motion. Question has been called. All those in favor? Any opposed? Motion is carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. Committee to clause 12 as amended. Does committee agree? Thank you, committee. To clause 13. Does committee agree? To clause 14. Clause 15. Clause 16. Clause 17. I hear agreement. Clause 18. Clause 19. Clause 20. Clause 21. Mr. Simpson.
Thank you, Mr. Chair. I move that Bill 30 be amended by A, deleting subclause 21(2) and renumbering subclause 21(1) as clause 21, and B, adding the following after subclause 23(2). 3, the following is added after subsection 53(3). 4, the Commission has carriage of a complaint before the adjudication panel. 5, the Commission may elect to have carriage of complaint in a proceeding before a court. 6, for greater certainty, the Commission has carriage of a complaint for the purposes of representing the public interest and upholding the principles of the Act. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion's in order. To the motion. Question has been called. All those in favor? Any opposed? Motion carried. Does the minister concur with this
Yes.
amendment? Sorry, again, Minister?
Yes.
Thank you, Mr. Minister. Committee to clause 21 as amended. Does committee agree? Thank you, committee. To Clause 22. Clause 23. Clause 24. Mr. Simpson.
Thank you, Mr. Chair. I move that paragraph 24B of Bill 30 be amended by deleting proposed subparagraph 62(3)(a)(4), or rather, sorry, Mr. Chair. I
I'll
made a
allow you to
mistake
start
there.
over.
I move that paragraph 24B of Bill 30 be amended by deleting proposed subparagraph 62(3)(a)(9) and substituting the following: to do anything that the adjudicator considers appropriate for the purpose of preventing the same or any similar contravention in the future. And thank you, Mr. Chair.
Thank you, Mr. Simpson. That's okay. Motion is in order. To the motion. Mr. Simpson.
Thank you, Mr. Chair. This is the bill that was proposed gives quite expansive powers to the adjudication panel to order compliance with anything in the Act, even if it is not related at all whatsoever to the part of the Act that was contravened. And so this just limits that power slightly, and I think it's good lawmaking, and I don't think the insurance industry has any problem with this one. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion. Question has been called. All those in favor? Any opposed? Motion carried. Minister, do you concur with this amendment?
Yes, I do.
Thank you, Mr. Minister. Committee to Clause 24 as amended. Does the committee agree? To Clause 25, does committee agree? Mr. Simpson.
Thank you, Mr. Chair. I move that subclause 25 of Bill 30 be deleted and the following substituted. 25, subsection 72(1) is repealed and subsection 72(2) is renumbered as section 72. Thank you, Mr. Chair.
Thank you, Mr. Simpson. Motion's in order. To the motion. Question's been called. All those in favor? Any opposed? Motion carried. Mr. Minister, do you concur with this amendment?
Yes, I do.
Thank you, Mr. Minister. Committee to Clause 25 as amended. Does committee agree? Thank you, committee. Clause 26, does committee agree? Clause 27? Clause 28? Clause 29? Mr. Simpson.
Thank you. I move that clause 29 of Bill 30 be amended by A, deleting paragraph 2D and substituting the following. D, section 21. B, deleting subclause 3 and substituting the following. 3, subsections 11(1) and 23(3) come into force April 1, 2021. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion's in order. To the motion. Question has been called. All those in favor? Any opposed? Motion carried. Mr. Minister, do you concur with this amendment?
Yes, I do.
Thank you, Mr. Minister. Committee to Clause 29 as amended. Does committee agree? Thank you, committee. We will now return to the bill number and title, Bill 30, an act to amend the Human Rights Act. Does committee agree? Thank you, committee. Does the committee agree that Bill 30, an act to amend the Human Rights Act, is now ready for consideration in committee of the whole? Mr. Simpson?
Thank you, Mr. Chair. I move that Bill 30, an act to amend the Human Rights Act, be reported to the Assembly as ready for consideration in committee of the whole as amended and reprinted.
Thank you, Mr. Simpson. There's a motion on the floor. The motion is in order. To the motion. Question has been called. All those in favor? Any opposed? Motion carried. Bill 30, an act to amend the Human Rights Act, will be reported to the Assembly as ready for consideration in committee of the whole, as amended and reprinted. Thank you very much, Mr. Minister, and thank you to your officials. If you have any closing comments, I'll allow you the opportunity to make them now. Mr. Minister.
Yes, I'd like to thank committee, in fact, all of those that did work on this very important piece of legislation. Interesting discussions, I know were held, so I look forward to hearing more from you, particularly on the issue that we found difficulty with. So thank you all.
Thank you, Mr. Minister, and thank you to everyone who is joining us online as well. It's great to have an audience and interest in our proceedings. With that, we are adjourned.